Hello, everyone. Nick Chavez here. Chavez and Valko, your key to immigration solutions. Here with my law partner, Martin Valko. How are you doing, Martin?
I'm doing well, Nick. Glad to be back with our followers, our viewers, to share our experiences with PIP.
Yeah, we're here to provide you the latest news on parole-in-place, PIP, also known as keeping families together. It has various names, but we're here basically to answer your questions. Though there's still some uncertain elements right now. We might not have all the answers, but we'll try. But we are limited in time today. So at the very least, what we want to do is to make sure we provide you with this important update before the weekend and take some of your questions. We know that some of you are feeling very anxious, and with all this litigation that's going around. But if we don't get around to your question, hey, no worries. Just go ahead and send it anyway, and we'll try to get a response to you. But quickly, before we begin, just a reminder: if you like our content, if you wish to keep informed about the latest news like PIP, don't forget to hit like and subscribe or follow us. We do really appreciate your support, and we love sharing our knowledge and insight with you. And we just hit the 5,000 mark last week on YouTube. Baby steps, Martin, baby steps. We're super grateful. And now we have our sights on maybe 10,000 subscribers. So please help us reach that goal. So Martin, it seems like it's deja vu again, right? We've seen this stop and go situation before with DACA in terms of litigation. And this could be the start of yet another crazy roller coaster. So here's the latest on the PIP program. Just as a quick refresher, we know that the PIP program was announced back in June, and it was created to help certain immigrant spouses of what they call mixed status families. Here specifically, we're talking about spouses of American citizens. Help them attain some legal protections here and possibly create a pathway to apply for a green card here instead of having to go outside. That's really the main purpose. And just to do a little timeline here, after the program was implemented on August 19th, it just like clockwork, the litigation effort began, and we saw an attempt to try and block PIP from happening. And about a week into the program, as expected, 16 Republican-led states, including Texas, no surprise there, right? And the group called America First Legal with Stephen Miller. Stephen Miller, you probably heard his name before. He used to be an advisor under the Trump administration. Well, they filed a complaint to block the PIP program, along with other motions and one motion for a temporary stay. And then the government filed their response. Then the judge assigned to this case, Judge J. Campbell Barker, who, by the way, was appointed by then President Trump, and by the way, was also Deputy Solicitor General for Ken Paxton. That person, he issued a stay of the program on August 26th. This means that it's a temporary suspension of the program. It wasn't a full stay or suspension. It was just a partial one, meaning that USCIS, while they cannot approve these applications, at the very least, they were allowed to accept and process these applications in the meantime, and also issue biometric notices. And that stay was ordered for 14 days, which expires this coming Monday. The judge also scheduled briefing for mid-October. But 3 days ago, on September 3rd, Judge Barker went ahead and extended the stay, which was going to expire, like I said, this Monday. He extended it through September 23rd. So this means USCIS, they could still accept and process PIP applications, but they still cannot accept them, at least until September 23rd. But the judge now has changed his mind about how he wants to process how he wants to proceed in his courtroom. He's ordered an accelerated hearing, meaning that we're going to have we're going to have a decision quicker than anticipated. Here, the hearing was scheduled for September 18th, which is pretty fast. And so the judge can make a ruling on this case by the end of September. So it sounds very crazy. So that's where we are now. That's where we're at. We'll know more about where this case is headed after the hearing on September 18th. But in the meantime, USCIS, they can continue to accept and process PIP applications, but they just can't approve them yet. Martin, I was wondering, what are your thoughts on how this case is proceeding so far?
Well, I mean, it's certainly we're seeing some type of a mirror image to DACA, to deferred action for childhood arrivals. It was stop and go. It was up and down, and everybody called it. We talked about it. How soon, when would the state sue? And they sued within the same week. And I just wanted to highlight the motion to, I believe it was a motion to suspend or motion to terminate the stay by the government, by the administration, which was, I think, 60-page long motion, which was fairly strongly worded. And I think that was the judge's reaction. He said, okay, this is pretty serious. In my opinion, the government had pretty strong arguments, and so they decided, the judge decided to push it, to move it up, and now we should have some type of a decision coming sooner. Obviously, the stay was extended by 14 days through the 23rd. Is it 50-50, right? There's some good things and bad things, but it's exciting, at least that it wasn't shut down, that it wasn't, like you said, there was a stay from even receiving the application. So we'll see on the 18th, and then we'll see what the update will be on the 23rd. But it's been positive. I mean, some clients are cautious, right, and cautiously optimistic, and like we are, but they're asking questions, good questions. I just wanted to again reiterate that this is not something that this is not an amnesty like some people are calling it, some pundits. Vast majority of the applicants have a way to do that, except the way is extremely long. We're talking about 5 years, 6 years. They have to leave after they get their waivers approved. I'd say with ours, it's probably 50% or 50-50 or even more have provisional waivers approved. So now we're just waiting for the final step to be called up for an interview in their home country. And that's where this unease comes in. Even though that was the original plan and it's still the plan in case something happens to this, they are going to have to separate from their family. They're going to have to leave. Once you cross the border, you just never know. Obviously, they'll be prepared and they'll be going there with the thought that they're coming back. But it's always uneasy when you have to separate from your family and wait for the decision and wait for the immigrant visa outside and then come back. So you're separating from your family, from your job. This program, it doesn't give somebody something that they're not entitled to, right? This is all within the power of the president. It's done by executive action. This parole program has been in place. It has been in use by several presidents before, and this is nothing new. And it's allowing those that already have a process, a lengthy process, expensive process, to do it here without separating. So it's a positive thing, and I hope that the judge will see it for what it is and will dismiss these suits.
Yeah, certainly beneficial for a lot of individuals who are in the process of applying for, like you said, legal permanent residence outside. And this could give them an opportunity to do it here. The whole purpose of keeping families together was to keep families together, exactly what it says. It's to avoid these separations, because we sometimes see it. For the most part, we screen our cases pretty well, and we try to minimize delay as much as we can. But there are situations that are beyond our control. When an applicant reaches their destination outside, they have that visa interview. Sometimes consular officers will drag their feet in making a decision, and the problem is that there's no way to come in on a temporary basis to be with your family. You're stuck outside essentially when there are decisions like that made. But yeah, this is very positive in terms of the it gives us some breathing room with this recent order. It's basically saying at this moment we are going to look at this carefully, and it's going to be accelerated. But at the very least, they're going to allow, USCIS is going to allow people to apply and file. They cannot approve it, but at the very least, if you wanted to, if you were eligible, you can put your application in. We do have a question here, and this is pretty much a very common question that we get. This is from Aurora Romo. It's regarding the 10-year bar. This 10-year bar that applies when a person has lived here for a long period of time. The law says that if you have lived here for over a year and have accumulated what they call unlawful presence, and if you leave the country, that triggers this 10-year bar. So you can't immigrate until you can show that you've been outside the country for at least 10 years. And there are ways to apply for waivers if you are eligible. So what are your thoughts on that, Martin? We hear our clients mention the permanent bar a lot, and they were concerned that the permanent bar might prevent them from applying for PIP.
Well, it's what it is. It's the permanent bar. We don't like it, but certainly we respect it. It's unfortunate. People have to leave for various reasons after they've been here for, like you mentioned, for a year, and they have to attend to their family. There's an emergency. They go, or simply they haven't really been explained what it is, and they'll just leave and they'll come back, and then time goes on, they get married, they'll come for a consultation, and you see that those entries and exits, you see the history, and you deliver the bad news that you are subject to this permanent bar. It's Section 212A9C under the Immigration Nationality Act. Some exceptions exist, but for the most part, your typical person would have to spend 10 years outside of the U.S. before being able to come back. So, it seems like that for the purposes of this program, people may be eligible to apply for the parole. However, they would not be able to go to the second step, which is the adjustment of status, and that's the reason why the parole has been enacted, so that people could kind of bypass the long process that you just mentioned and be at the will of an officer and be subject to administrative processing, which we both know, could go on weeks and months, and that creates the separation. So, nobody likes the permanent bar, and that could happen when you have an expedited removal order at the border. And a lot of times people, they attempt to come in, they get detained, and they have prints taken, and they don't even know that. They said, well, they sent us back. They send me back, but it could have been pursuant to expedited removal order. And then that as well, if you have one and you return without inspection, without a visa legally, then you are subject to this permanent bar. So it is a statute. It would have to be a greater or more bigger comprehensive reform that would take care of this particular bar, Aurora. So we don't like it.
Yeah. And there are really two groups that fall under the permanent bar. When somebody says, hey, I think I fall under this permanent bar you guys were talking about, there are people who are trying to apply for a green card, have lived here for a long period of time. They left the country and they returned, and that triggered this 10-year bar. And there's another group of individuals who were here in the United States, were ordered deported, meaning they were placed in court proceedings, and the judge said, you know what, we're going to order you deported. You can't come back for a certain period of time. Or maybe this person was trying to come in the United States and was ordered deported at the border, and then they leave and then they come back in. That group, that's where where we have to really look at the case. And if the person has returned after having been ordered deported, they're not eligible for PIP. And so we have to be really careful on those situations. Sometimes our clients will say, hey, I've been here in the United States. I was here and then I was I was arrested and I was transferred over to ICE, and they made me sign some paperwork, and they took me outside. They took me to Mexico. Or it could be a person who tried to enter, was caught by Border Patrol, and again, Border Patrol had them sign some paperwork, and then they returned them to Mexico, and then the person entered illegally after that. Those individuals, they might not be subject to an order of deportation. We have to look at their records carefully, because sometimes, although it may seem like they were ordered deported, if we discover it further, it might not have been an order of deportation. It could have been what's called a voluntary departure. So, yeah, it's always good to talk to a lawyer if you had any kind of encounter with immigration. Another type of questions we've seen, right, is this one, is, what happens if I'm common law married to a person? And we've certainly had several questions from our clients who were not married officially, but they were common law married. Are those people eligible for PIP?
Are they ineligible or eligible? What was the question?
Are they eligible for PIP?
They are eligible. Texas is one of the handful of states in the union that allows for common law, that recognizes common law or informal marriage. Yeah. And so they are eligible if they have been informally or common law married on June 17th of 2024, which is one of the requirements of the PIP program. And so in simple terms, common law marriage requires three elements: that the persons, that the couple agreed to be married, that they cohabitated as a married couple, and that they held themselves out to the rest of the world as a married couple. And as long as those requirements, those elements were met, they don't even have to go down and have an informal marriage certificate, but certainly makes it easier for USCIS to see that's when they see a specific date for common law marriage. So certainly it is, in Texas at least, which is a state that recognizes common law marriage, acceptable for PIP.
Yeah. We have a question here from Julieta Alvarez. She asks about the processing time here, specifically about the biometrics. She submitted her parole-in-place application on the 21st. And hasn't received her biometrics, and she's seen other situations where they might have given her that person their biometric notice sooner than later. Is there a certain order to the chaos? Well, we know that individuals, at least the cases that I have, if they have submitted their biometrics in the past, and this could be individuals who filed their provisional waiver applications, they were required to submit their biometrics in the past, or it could be people who are currently in the DACA program, they certainly had to submit their biometrics. We've seen in those situations, as soon as we file the application, we see that they're repurposing, or they're reusing the old biometrics. So they're not, it doesn't seem like they're issuing new biometrics, a notice for new biometrics for individuals who have provided in the past. I mean, that could change, but that's the trend that I'm seeing. How about you, Martin?
There was also a little chaos in the beginning where people got scheduled and they got descheduled as well. So I wouldn't really read too much into it. It's USCIS accepting thousands of applications, and so just like with any other program, there's always chaos. There's until the dust settles and they kind of get into their ways and they know the process. I wouldn't read much into it. Plus, when you count into this whole thing, the lawsuit that was filed by the states, that caused a ripple in this as well. So we'll just see what the developments will be on the 18th, what the hearing is going to be about on the 18th, and then if there's going to be additional extension or a decision on the 23rd. But I wouldn't read much into it, Julieta. It's if you submitted your application, you've paid for it, then you should be, and you haven't had your biometrics taken in the past, then your notice should be coming.
Yeah, we've seen it across. It's all over the map. We've seen applicants who submitted their PIP already, and they haven't received their biometrics notice yet. So, as Martin said, it's something. What we do recommend is that you regularly check your profile, because there could be, I would say check it every day. Sometimes immigration, they're supposed to email you and say, "Hey, we got an alert. We got a notice for you. Please look at your account." Sometimes they don't do that, so you're gonna have to be looking and making sure that you're on top of it. Thank you, Julieta, for your question. As far as criminal situations, that we also have had individuals who may have had a criminal past. Maybe they were arrested for a DWI or something more serious. What has immigration said regarding applicants with criminal histories? Are they eligible to apply for a PIP?
Well, basically the requirements rule out any felonies and certain misdemeanors and certain crimes with certain elements to them, and there's a list of them. But typically, first of all, you have to disclose it, whether it was a juvenile record or whether it was a record attained as an adult, and then you basically have to balance the negatives, which is the conviction, with the positives, which is positives of the person's good moral character, and in those cases, those are the cases for us as attorneys. They tend to take a bit longer because analysis is necessary. We have to do the balancing, and we prepare a letter where we present the person and argue and advocate for the grant, and certainly want to show that the person is then eligible for the second step, which is adjustment of status. And so that's that analysis that we go through.
Yeah. So basically here, what we're doing is we're waiting. We're waiting for what the judge how the judge will rule on this case. It's an interesting case, but we've seen this type of song and dance before in other situations, in other contexts, where there is an immigration program and you have Republican-led states challenge it. And what we've seen is, and this is going to be an important issue, is this issue of standing, meaning that if you are filing a complaint or a lawsuit, you have to show that you have standing, which means that you are being harmed, that there is an injury that you are suffering or will suffer as a result of this action, and that there is a remedy, that it's redressable, that the court has a solution and can fix it if they can. But that's where it's going. I think you're going to see the states try to argue that they are being injured because of this program. They're already saying that this program is an incentive for individuals to cross, illegally, and therefore the state is going to use up its resources in education, healthcare, etc. And by and in doing so, that's causing harm. And on the other side, the government's going to be arguing, well, that's so general. This harm has to be specific. It has to be concrete. It's very speculative. And I think that's where you'll see a lot of the arguments. We're going to be hearing a lot of that. It'll be very interesting. And then after September 18th, we'll get an idea of where this judge stands and how they're going to rule. But if the judge does agree with the states and shuts this program down, of course, the government will appeal it to the Fifth Circuit, and this is where they'll ask the court if they can have the program operating while the case is on appeal. So again, you're starting to feel a little bit, hopefully not, but it's starting to feel a little bit like the DACA roller coaster that we were in. Well, get with that. I know that you have to go, Martin. We just wanted to bring this this important update to y'all, and we really appreciate that you are watching, and we like your comments. Don't forget to hit like and subscribe as we try to reach that goal of 10,000 subscribers, and we really thank you for your support. And Martin, we'll be back at this next week. I don't suspect that we're going to talk much about this program because they're not going to have the hearing until September 18th. But this is something that we'll be watching and monitoring. If you have questions about the PIP process itself, maybe we'll have shows on offering tips on how you could submit a good PIP application in the meantime. Folks, that's it. Martin, any closing words?
That's it. Just let's be hopeful that things will turn out positively, and this will continue. And until next time, have a good weekend.
Thank you, guys.